Hello, I'm Michael Tassone. I prepared this presentation entitled ACCC Cheat Sheet March 2024. And I guess if you've been looking at my YouTube channel a bit, you know that I do these every month and try to summarise all the events that occurred in the previous month in relation to ACCC. And it's effectively a bit of a summary of their media releases and the major cases coming along. So a bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice to Sale Law Consulting for about 17 years now. And I help companies with competition and consumer law matters. Also do some expert consultancy work for various legal publishers on competition and consumer law. And recently I've been appointed as a general member to the New South Wales Civil Administrative Tribunal. Prior to that, I worked at the ACCC for about 15 years in a variety of roles, including enforcement and in mergers. Now, the outline's pretty straightforward. The big thing probably in March was the release of the ACCC's compliance and enforcement priorities for 2024-2025. So I'll go through that in a little bit of detail. Been a bit of court action, 3 court cases, not a whole lot of enforcement action, a couple of mergers, 1 scam notification. A real lot happened in relation to inquiries and consultations. I've tried to summarise it best possible, and 1 other matter. Now, the priorities were released on the 7th of March 2024, and what they do nowadays is cover the financial year from obviously 1st July to 30th of June the following year, and that mirrors the ACCC's annual report. Previously, they used to go from February to February, which was not ideal timing for reporting purposes. So the key here is that the ACCC reports in its annual report to Parliament on how it has met its priorities. So obviously it makes it a lot easier if they're reporting the same period as in the annual report. And I think it's fair to say a large amount of the ACCC's budget is directed to these particular priorities. So when they say they're going to be looking at particular areas, they follow through and do look at those areas. So I guess if you're on the list, if your industry's on the list, you definitely should be very careful and probably expect some activity in your sector. Now they've got 2 types of priorities. The first, one-off, so effectively for a year or a couple of years, and then they have enduring priorities, which are always going to be a priority for the ACCC. Now here's the list of the one-off sort of priorities, and as you can see, environmental claims and sustainability is the first one, and that was introduced last year, so it's remained as a enforcement priority, and I think it's fair to say that ACCC hasn't done a huge amount in this area yet. They've had a couple of cases in relation to the sale of these containers, claiming that they were reclaimed from the ocean, plastics, and turned out not to be correct. One case actually in court at the moment, but they haven't done a whole lot, particularly compared to ASIC, who's run over half a dozen cases in this space. The second issue is supermarket sector, and I think that's a very big area. The government has given them a role in relation to conducting a review of supermarket grocery pricing and looking at various factors that are impacting the cost of living crisis that everybody's talking about. It's also proposals to make the grocery code mandatory, which would obviously give the ACCC a much bigger enforcement role in relation to that code. Promoting competition in essential services, telecommunications, electricity, gas and financial services. That's been a priority for the ACCC a number of years now, particularly with cost of living crisis. Everybody's talking about these areas have to be competitive. Misleading pricing claims in relation to essential services, particular focus on energy and telecommunications. So as you can see, one of the priorities relates to competition in those markets, and the second relates to misleading conduct. So they're looking at both sides of, I guess, their jurisdiction. Competition and consumer issues in the aviation sector, which is sort of a newish one. Obviously, looking at competition in the aviation sector is very important, but there's also the large Qantas case that's going through the course at the moment about the cancellation of flights. So they're going to be stepping up their interest in that area. And I guess I've just prepared this presentation hearing the news that Bonza has gone into voluntary administration. So obviously the level of competition in the domestic market has reduced significantly in April. Then Consumer and Fair Trading issued Digital Economy, focused on misleading and deceptive advertising, influencer marketing, online reviews, in-app purchases, and price comparison websites. So as people are aware, the ACCC has been issuing a number of digital platform type, digital economy type reports, looking at a lot of different issues, and clearly that activity in that area is going to increase. And there's also suggestions that the government's going to take up some of the proposals made by the ACCC to introduce specific codes of conduct for different sectors of the digital economy. So that's something we might be seeing some activity in relation to shortly. A new area is actually improving compliance with NDIS providers. And the view here is they may be misleading consumers. I guess there's also some suggestion of unconscionable conduct, potentially not providing services that they're contracted to provide. So it's interesting. It's another area which you wouldn't traditionally expect the ACCC to get involved in, like childcare, but they're actually on a task force to really investigate whether there's anything untoward happening in the NDIS sector. And I guess it'll be broken up into obviously consumer competition issues with the ACCC, but other types of misconduct will be pursued by other federal government regulators. Unfair contract terms in consumer and small business contracts. I guess we can expect to see some penalties coming through this year with the introduction of penalties for breaching those provisions. Improving industry compliance with consumer guarantees with a focus on consumer electronics and targeting misconduct by retailers in relation to delivery timeframes. So consumer guarantees, unfortunately, has been on the list for many years. There seem to be still significant problems in consumer electronics. White goods suppliers seem to have been removed from the list, so that they've obviously got the message. But also delivery timeframes is a big concern, and there's some litigation that was commenced by the ACCC in relation to that issue in March, which I'll discuss shortly. Consumer product safety issues for young children with a focus on the safety of nursery products, furniture, infant self-feeding and infant sleep products. So that's been there for a while, and that's obviously a very important area for the ACCC to focus on. Then there's enduring priorities, and these are the priorities which remain number one priorities for the ACCC every year. And I must admit they've been the same for many, many years, but they've actually changed them and added a new one in 2024, 2025. Obviously, cartel conduct is a priority. That's both civil and criminal prosecutions. And I guess what I talked about last month was the very significant case taken against Bingo and Aussie Skips in relation to a very short-term cartel. Anti-competitive conduct, so that could be clearly cartel conduct, but also looking at anti-competitive agreements, exclusive dealing, things like that. Product safety, so that's obviously a high priority and remains a number one issue for the ACCC to look at. Consumers experiencing vulnerability or disadvantage, so that's been a enduring priority for a number of years now, and they do a lot of activity in relation to maybe remote communities, people who may not have this level of sophistication to buy sophisticated products. Conduct impacting First Nations Australians, so that's been a priority, enduring priority for a number of years now. It's very important. Unfortunately, a lot of unscrupulous people go to remote communities and rip off First Nations people, so that's a really important area for the ACCC to be very active in. The new one is small business. The ACCC is committed to ensuring that the protections of competition, consumer laws, and small business industry codes are codes of conduct apply to small businesses and the agricultural sector. So that was an enduring priority last year, and so that's going to be there in the future. As you can see, it's going to be looking at things like the franchising code, which Michael Shaper has just issued a report on and made a number of recommendations about. Also, you're looking at the horticulture code, which the ACCC has been very active in relation to. And I think probably the grocery code, it's likely to become mandatory and big penalties are going to be applied. So that's obviously going to help a number of small business suppliers. And obviously scams is, I think, a new one as well. The National Anti-Scam Centre was set up, doing some really great work. And so clearly the ACCC has to be at the forefront of seeking to disrupt scams, particularly given most of the sophisticated scams are being run by organised crime groups. So the thing to remember is even though they're on the list, it's not like they're just going to go after any cases in that area. They do apply other considerations when selecting a case to pursue. And as you can see there, they point out that they're not going to pursue a case in a particular area unless it ticks some of these boxes. So significant public interest or concern, substantial consumer or small business detriment. And this is interesting, a significant impact on the cost of living. So that's new, that wasn't there before. So clearly looking at cost of living impacts in their priority, assessing what cases to pursue. National conduct by larger retailers or traders that has a greater potential for creating detriment. Conduct which impacts or disproportionately targets consumers who are vulnerable or disadvantaged. Significant new or emerging issues, so clearly the digital platforms is the key there, and with action will help to clarify aspects of the law. So I think there's a case where the ACCC has appealed or sought special relief to the High Court, which I think is about trying to clarify the law in relation to agreements. So the case I just referred to was actually the Hutchinson case, where the ACCC sued both Hutchinson and the CFMEU for effectively what was a boycott. And what the court found at the first instance was that effectively the CFMEU and Hutchinson had entered into an agreement to kick off a waterproofing company from the site because they did not have enterprise bargaining agreement with this CFMEU, and that was alleged to be a breach of Section 45E. And then it went to the penalty hearing in late August 2022, and the judge there decided to impose pretty significant fines, given the maximum fines that are available for these provisions. So 600,000 for Hutchinson and 750,000, which was the maximum for the CFMEU. And that was appealed, and I was probably a little bit surprised they appealed the case, but they appealed it and they were successful, both the CFMEU and Hutchinson. And effectively what the full court decided was that there was insufficient evidence to support the inference which the primary judge had drawn, that there was an agreement in existence between CFMEU and Hutchinson. So if it's an agreement between an employee organisation and a company, then it falls under the terms of 45E and would be a breach. But what the court in the full federal court decided was that the evidence was really insufficient to draw that inference. Rather, what they believed was the case, that there was an equally plausible or reasonable explanation for the conduct, which is basically Hutchinson were scared of action by the CFMEU to boycott their site, so they made a unilateral decision to terminate the waterproofing supplier. So the irony there is it's almost like saying that the ACCC decided to take a 45E contravention when it was actually a vanilla 45D arrangement, a classic secondary boycott. So I guess there might be reasons why the ACCC decided to take a 45E, but reading the full court decision, you're saying, well, they've sued them under the wrong provision. If they'd sued it on the 45D, they would have been successful, but suing them under 45E meant they had to establish an agreement. Now, the ACCC has actually sought special leave to appeal that to the High Court. It's obviously not very happy with some of the law that came out of the full federal court decision about how to define an agreement, or maybe it thinks it's a good vehicle to get some clarification from the High Court about agreements and how to define them. I'd be somewhat surprised if they actually got leave for this case. I have a feeling they may not get special leave. Now, the second case, a very interesting case where Ultratune actually got done for contempt of court, and this arose from an earlier case where the ACCC found or alleged that they had breached various provisions of the Australian Consumer Law and the Franchising Code. And that case related to failure to provide various documents to franchisees. There was also some serious allegations about tampering with various documents to maybe mislead the courts. So it was quite a serious case. And one of the orders made by the court was that Altitude had to provide disclosure documents and marketing fund statements to franchisees within the relevant timeframes, and also to implement a compliance program. And the ACCC took contempt proceedings against, or commenced contempt proceedings against Altitude, alleging that they'd failed in some of those obligations. And as you can see, the court found that on one occasion, Altitude failed to update its disclosure document on time. Actually, on two occasions, it failed to prepare its marketing fund statement on time. And on one occasion, it was actually almost 8 months late. And then also, the compliance officers appointed under the relevant relevant compliance program had failed to report to the board as to the effectiveness of the compliance program. So that was contained in the compliance program obligations. So they were the obligations that were found to have been breached, and Justice Bromwich found that they had engaged in contempt and imposed a fine of $1.5 million, which is a significant penalty when you think about it for contempt. And Altitude has appealed the decision to the full federal court. I have a feeling the full federal court will have a close look at this particular case. They might think 1.5 might be a bit on the high side for this particular conduct. Got to wait and see. The next case, I won't talk a whole lot about this case because I've actually been hired by Blumex to help it with its compliance program, so they're a current client. But effectively, the ACCC took action against Blumex, alleging misleading conduct by them in relation to strike-through prices, saying prices were half price, 50% off, when the products had not generally been sold at the higher prices that were represented. Also, they displayed the star ratings on their website, and they had changed for many years. And it turned out that some of the customer reviews were for customers outside Australia. So Blumex is an international company with operations, I think, in Canada and the US, and so some of these ratings weren't actually Australian customers. And finally, there was an allegation they failed to disclose these surcharges which would apply on orders made on its website. So Blumex ultimately admitted those three breaches, and they were fined $1 million, which seemed a bit on the high side to me, I guess, for admitting various breaches. It was very quick very quick decision between the hearing and the decision. So the Justice Stewart turned out this decision very quickly. And obviously, the other order is to implement a compliance program. So that's what I'm assisting Blumex in doing at the moment. Now, there's only one enforcement matter in March, and this was against Mosaic Brands, who's had quite a lot of trouble with the ACCC over recent years, and this seems to be a very serious case. Effectively, Mosaic Brands owns a number of very high-profile brands, Noni B, Rivers, Katie's, Rockman, Miller's. The rest I haven't heard of, but I imagine they're probably pretty well known to younger people than me. And the ACCC has alleged three things, are pretty serious allegations. Firstly, that the company made false and misleading representations that it would deliver products purchased online within particular timeframes. It wrongly accepted payment for goods during the same period when it failed to deliver the orders within the advertised timeframes, within a reasonable time frame, or at all. So that sounds pretty bad if the product never actually arrives. And misrepresented consumer guarantee rights, saying that 8 of its brands' websites, basically customers were only eligible for a refund if the product was faulty, and they sought a refund within 6 months. It's quite remarkable that large companies are making those sort of mistakes. These laws came in many years ago. So this is a very serious case. ACCC is going for everything: declarations, injunctions, penalties, costs. And I was very surprised to see implementation of a consumer law compliance program. And the suggestion there is they don't have one, which is quite remarkable. A company that doesn't have a consumer compliance program, and it's been in trouble before, so I don't quite know why the ACCC didn't make that a requirement. But clearly this suggests that they didn't have a proper compliance program, and various things really just slipped through. It'd be interesting to see whether Mosaic Brands fights this case or seeks to settle it. The next area was mergers. There wasn't a whole lot of activity in March. The key thing here was ANZ Suncorp, the decision of the tribunal. The full decision got handed down. Quite a long read, so if you have a spare 10 hours, you can read that. But effectively, the tribunal found that, contrary to what the ACCC thought, the merger was not going to substantially lessen competition. So it's probably going to lessen competition. I think most mergers lessen competition to some degree, but the test in the legislation is substantial. So if it's not going to substantially lessen competition, there's no detriment. So that means any public benefits, even if they're minuscule, are going to outweigh any anti-competitive detriment. There's effectively no anti-competitive detriment. So the key thing that ACCC said was that once it got the full decision, read through it, it decided it wasn't going to appeal the case to the full federal court. And I guess that's saying, well, do we really want to try this case and push it to the next level? Are we going to be successful, or should we just move on? I guess there's also an element of, like, the treasurer, the Chalmers, has to decide whether to approve it. So that's a different test, really based on, national interest. So there's a possibility, I guess, that he might say no to the merger. He doesn't believe it's in the national interest. It's not necessarily anti-competitive, as found by the tribunal, but he might not think it's in national interest. And as of the date that I'm doing this presentation, which is late April, the Treasurer hasn't made a decision. So obviously he's thinking about the issues quite hard. The next merger was GrainCorp buying XF Australia, which I didn't know what XF Australia did, but it's an animal feed supplement supplier. And the issue here was whether the overlap between the two companies was going to result in a lessening competition. And as you can see there, the ACCC was satisfied that GrainCorp would still face significant competition from other animal feed supplement suppliers, and got some examples there, and also didn't believe that the proposed acquisition was going to create an ability or incentive for the combined entity to reduce molasses suppliers. So effectively prevent maybe downstream competitors from getting access to the relevant products to compete in those downstream markets. So there was one scam announcement that by the National Anti-Scam Centre, and this related to celebrities allegedly endorsing various online advertisements, investment opportunities, and it's warning people about these scams. They're very prevalent. I guess the high-profile one that everybody's aware of is Twiggy Forrest, who took a case against Facebook for scammers using his face to promote these online investments. And as you can see, they entice these scammers entice victims through social media, deep fake videos, video sharing platforms, and fake online news articles. So it's very, very sophisticated. They use fake clickbait to link the scam website where the victims are prompted to enter their details. They ask for a small amount of money by credit card to access the platform. Then they will seek to encourage the investor to download a third-party trading platform. So this is probably something that may be off the grid and not able to be traced as easily as some of the online platforms. After showing profits through a dedicated online dashboard, scammers will persuade their victims to invest more. So it might be a dashboard which shows the person's made lots of money and they get excited and they encourage to invest more, but in reality they haven't made any money at all. And then sometimes they actually allow the victim to deduct a bit of money to enhance their confidence in the scam. So that's the more sophisticated scams would allow that. But then when the victim eventually tries to withdraw the funds, and then as you can see at the bottom there, that when some people seek to withdraw the funds that they think they've made from this online investment, the scam will tell them that to get your money out, you've actually got to put more money in, withdrawal fees or various tax issues to try and get more money out of the person. And then I guess if things are getting a bit uncomfortable for the scammer, they'll just end up locking the person out of the account. So these are very common out there, and a lot of high-profile celebrities and well-known people have been implicated in these. They've had their images used and their names used in a lot of these things. And I think the interesting one was the ACCC has actually taken some action against Facebook for this thing. And as I mentioned, Twiggy Forrest has been very anti the sort of conduct, and he has commenced proceedings both in Australia and in the US against Meta for failing to protect people like himself from being the subject of these scams. But unfortunately, he got permission from the Attorney General to run a criminal prosecution in Australia. And then recently, the DPP came and took it over and dismissed it, which I thought was a bit a bit unfair. After all the money's put in, all the effort is put in, he gets permission, and DPP close it down. But he's still got cases running in the US, and the ACCC case in Australia, which is quite similar to his criminal prosecution, is still going. Now, inquiries consultation, there was a heap of stuff happened in March, so I've sort of summarised it a bit. And clearly, if you're really interested in this area, you just got to read the reports. But first was the wholesale price controls report, 12th of March, and in this particular report, the ACCC decided to make a final wholesale access determination in relation to this superfast broadband access service, SBAS. And there's only a couple of providers of those services. So under this declaration, the prices for the wholesale prices will be set, a maximum price will be set, as well as other terms and conditions. That's probably not great news for the suppliers of that particular service. I think it's TPG is one of them. Then the NBN report came out, and it shows how competitors are doing against the three biggies, obviously Telstra, Optus, and TPG. And as you can see, smaller broadband providers, Aussie Broadband, Vocus, and Superloop, gained over 62,000 NBN wholesale services in the December quarter, so that's a huge amount. And the total number of residential broadband services on the NBN remains steady. So effectively, these three providers are getting customers off the big three. So that's, I guess, good news in terms of competition. Then the internet search inquiry. So the ACCC has been doing digital platforms reports for a number of years now, which have been really exceptional. And they started the next one, which is to look at internet search. So the first step is they're seeking views on the level of competition in general search services, and trends in search quality. So they're asking consumers for their views, and they've issued a issues paper so people can answer the various questions. So it'll be interesting when that comes out. Clearly, Google has such a dominant position in that market. It'd be interesting to see whether there's been any movement in terms of their very, very strong position in that market. I think previously the ACCC found that Google actually had a substantial degree of market power in that market. Then the Australia Post price increase. Under the legislation, Australia Post has to ask the ACCC for its views about whether it can increase its prices, and this relates to the reserve services, which is the ordinary letter service, which very few people use nowadays except for Christmas cards. So they proposed pretty significant price increases, and the ACCC conducted a bit of an inquiry and came out with the view that they would not object to it, but that's really not... it's important that they've done the work and come out with that view. But ultimately, it's up to the Minister for Communications to make the final yes or no. And she can actually oppose the price increase if she doesn't think it's reasonable. The retail petrol prices report came out, and they've been doing these reports quite regularly. And it said, it's quite interesting, but the retail petrol prices in Australia's 5 largest cities trended downward in the December quarter. Also, diesel prices were trending downwards, and this is due to international factors. Obviously, international refined petrol prices decreased, increases supply and all the rest of it. But the ACCC did note that prices remained relatively high. So I think there was a suggestion that maybe there'd been too much of a lag on the prices going down, maybe a bit of profiteering. They didn't really make that very explicit in the media release, but the suggestion in the title of the media release was they were concerned that prices were maybe higher than they would have expected. Then they issued the Internet Performance Report. So they're obviously looking at who's getting the NBN customers, but also how Internet's performing. So as you can see that in December 2023, the average download speed for NBN fixed line connections across all speed tiers was 99.3% of the connection's maximum speed plan. So that's really good. That's been rising over a few years now. I think 100% is probably not going to happen, but it's very, very high. So obviously they've been improving the network. Now, the number of consumers on fibre to node connections that were underperforming on the NBN 100 megabytes per second plans remain relatively high. So that's not good. Even though the average download speed is 99.3, there is a noticeable underperformance on the NBN 100 megabyte plan, which is an expensive plan. So that's something that NBN has to really look at. And then NBN fixed wireless connections recorded average download speeds during the busy hours of 97.9%, which is up from 89.5. So that's good as well. It's obviously not as high as fixed, but that's pretty high. So that's improvements there. Then there was the Wholesale Telecommunications Inquiry, and this relates to the 9 declared services. So it's a big report. And as you can see, I've listed the 9 different declared services and what the ACCC decided in relation to each one. So you can see domestic transmission capacity service. So it decided to extend this declaration for another 5 years with some geographic exceptions. So in some geographic areas where there's significant competition, the declaration won't apply, but it'll generally apply across a lot of areas. And the main thing here is to look at the level of competition in geographic areas where there's sufficient competition, that doesn't need to be in the controls, but where there isn't sufficient competition, the price controls remain. The wholesale line rental, that was extended for 5 years. The local carriage service declaration was extended for 5 years. And this is because these particular markets do demonstrate some bottleneck type bottleneck characteristics. So competition isn't fully effective in those markets. So it's got to remain subject to declaration. The basic ADSL service was also extended for another 5 years. Unconditional local loop service will cease being declared later this year. The line sharing service will cease being declared as well later this year. So that's 2 off the list. The fixed originating access service and the fixed terminating access service both been extended to June 2029. So they're going to be probably not declared after that date. So that could be another 2 off the list. And then the domestic mobile terminating access service is not part of this particular report. That's subject to a separate report. So as you can see, a lot of declarations are going. Competition seems to be manifesting itself in some markets. So it could go from 9 declared services down to 4 potentially. Probably more like 5. So that's good that the competition is manifesting itself in the markets and the need for declarations is being removed. The other big inquiry that sort of kicked off recently was the grocery price inquiry. And as I said earlier, the government's given the ACCC a wide mandate to really look into this. And the first thing they did was set up an online consumer survey. That was I think, a really good idea, and they got that out. And it wasn't open for very long, but 13,000 consumers had already jumped on and filled out the survey. It closed in early April, the survey, so they probably would have had another few thousand consumers getting on there from the 28th of March to early April. And the preliminary findings from this survey were that many younger Australians and lower income households are spending up to 1/4 of their net income on groceries. That's very concerning. 1/4 of their net income, not that's a huge amount, particularly if they're paying rent or even a mortgage. There's not really much left for other activities. And then the next finding was households have claimed that to reduce their grocery bills, they're spending more time shopping around for savings. So that's probably all right. Substituting fresh food with frozen, that's very concerning, and cutting back on non-essential items. So that's really supports the concerns about cost of living crisis at the moment. And then as the final line there says, consumers consider the price of groceries to be a major factor in the cost of living crisis. So that obviously follows. Now, the other thing that's happened was another one of these agreements or MOUs with a regional competition agency. This time, the Vietnam one was re-signed, so they've had one for a number of years, and they're trying to work much more closely. I guess trying to develop best practices that being developed through various organisations, exchanging officials, actually working maybe together on mergers that impact both countries, so sharing non-confidential information and periodic study visits. So that's a good thing to, I guess, assist some of these newer competition agencies to get up to speed. So that's been a pretty busy month. I guess ACCC priority areas are the big news. A lot of commentators said there was nothing really new to see there, but I totally disagree. There was quite a number of new areas in the priorities and two new enduring priorities. So it was a pretty big change, I thought, to the previous things, and the priority factors which people look at or the ACCC looks at in deciding to pursue some enforcement action, they change as well. There's cost of living issues are now one of the factors that may encourage the ACCC to take some enforcement action. So they're pretty big changes, and I think people shouldn't just assume it's like a repeat of the previous year's priorities. The Hutchinson CFMEU High Court appeal is potentially very significant if the High Court grants special leave. It's really ACCC asking the High Court to look at the whole way that agreements are inferred from conduct. I just don't think the High Court's going to find it the best vehicle for that issue, and I doubt they're going to get special leave. The Mosaic Brands case is really interesting. I think it sounds so serious. Mosaic Brands been in trouble a few times before, and I think they, I don't know the evidence, I guess, in any detail, but it could be potentially a very large fine. So I think they'd be very strongly encouraged to look at all settlement options as soon as possible, and I guess put in a compliance program straight away. Don't wait till the court case is over. Just do it straight away, because obviously their compliance has let them down. Some of the things have been alleged should have been picked up by a proper compliance program. So get that going ASAP. The ANZ Suncorp, I was probably a little bit surprised ACCC didn't appeal that, but I guess you got to read decisions, see if they made any errors, and obviously the ACCC didn't think there was anything majorly wrong with their decision. Maybe they're also hoping the Treasurer steps in and says no, but which would be unlikely, but they decided to move on from that merger. Internet search inquiry is going to be significant. I don't know whether the findings are going to be particularly earth-shattering. I think Google's position in the market hasn't changed, probably more entrenched than it was previously when they ACCC found they had market power. But these reports are just so good, they're just so insightful, and I look forward to the next one coming out. And the supermarket inquiry is going to be very interesting. I think the ACCC are very capable in seeking information. Putting out a consumer survey straight away was a really great idea. Talking to different parties, I think they'll be using a lot of their coercive powers to get information from the major grocery chains on margins and other activities they're engaged in terms of the way they deal with suppliers, terms and conditions that they impose. So that's going to be a very in-depth inquiry, and I think it'll be interesting to see what the ACCC comes up with. That's all I had for this particular month. It's been an interesting month, I guess. A lot of inquiry work, not much enforcement. So it'll be interesting to see if ACCC catches up a bit in the enforcement front in April. So if you have any questions about the particular presentation, feel free to give me a call or drop me an email. Bye-bye.